You're listening to the Valley Current.
Imagine standing at a podium right in front of your state Supreme Court.
Oh, man.
Yeah, you are arguing this really complex, life-altering divorce appeal, and the chamber is, dead quiet.
The pressure is just immense in that situation.
Exactly. And the lead justice leans forward, looks down at you over their glasses, and asks a very simple but just completely chilling question. They say, "Counselor, why do 20 of the legal cases you just cited in your brief literally not exist?"
The sheer panic of that moment, it's hard to overstate. It is the absolute worst nightmare for any legal professional.
Totally.
Your credibility, your career, your client's entire future, it just instantly evaporates in open court.
And the most terrifying part, that's not like some hypothetical scenario. That actually happened in February 2026.
Right.
The attorney standing at that podium didn't intentionally forge those cases. A machine did. And the attorney simply trusted the machine.
Which is why we are witnessing, really, an epistemic crisis in the courtroom right now. The fundamental concept of verifiable truth, which is the absolute bedrock of the justice system, is currently being eroded in real time by the very tools that were supposed to make the law more efficient.
So welcome to this deep dive. I am the host, and I'm so glad you're joining us today because we are unpacking a staggering new reality in the legal world.
And I'm the expert for today's session, thrilled to be here to break this all down with you.
Awesome to have you. So our mission for this deep dive is to explore exactly what happens when the absolute truth required by the justice system collides head-on with the creative, unpredictable, and, entirely probabilistic outputs of generative AI.
It's a massive collision.
It is. And to do this, we are looking at a deeply sourced, incredibly data-heavy legal briefing. It's the May 2026 edition of the CLG newsletter.
Right, specifically their bench and bar briefing on Judicial AI.
Exactly, authored by Jack Russo, the managing partner at Computer Law Group, LLP.
And the scope of the documentation in this newsletter, it is breathtaking. We aren't looking at theoretical white papers here about what might happen in the distant future.
No, not at all.
This is a real-time damage report from the front lines. We are looking at documented AI hallucinations in courts worldwide, tracked meticulously all the way up to May 2026.
Yeah, we're looking at shocking statistics on AI usage by federal judges, and we are going to explore the massive, life-altering financial and professional sanctions that are currently hitting the legal industry.
It's affecting everyone.
It really is. So whether you are a corporate executive signing massive commercial contracts or, someone going through a routine legal matter like a property dispute, or just a citizen relying on the rule of law to keep society functioning, you need to understand this.
You really do.
You need to understand how artificial intelligence is secretly writing the rules that govern your life.
Because the entire legal profession, every brief, every ruling, every contract is built on historical precedent.
Right, looking backward.
Exactly. It requires a backward-looking assurance that something actually happened or was actually decided by a human judge. Generative AI, however, it doesn't possess a concept of history or truth.
No, it doesn't.
It is a probabilistic engine predicting the next most likely word in a sequence.
Okay, let's unpack this because I am just marveling at the sheer speed of this technological shift. We have to look at where this crisis started.
We do.
And before we look at the judges sitting on the elevated bench making the final decisions, we really have to understand the baseline that was set by the lawyers standing in front of them. The court saw this technology coming, and they initially tried to draw very clear lines for attorneys.
They attempted to establish a human firewall, and the foundational case that set the stage for this entire discussion happened in 2023, Mata v. Avianca.
Oh man, Mata. For those who aren't steeped in legal tech lore, let me set the scene because it is just wild.
It really is.
You have two attorneys, Stephen A. Schwartz and Peter LaDuca, working on what should be a relatively standard personal injury lawsuit against an airline. Right.
The airline files a motion to dismiss the case. The attorneys need to file an opposition to that motion, basically arguing, no, the law says our case should proceed. But to find the law to support their argument, they didn't use a traditional legal database.
No, they didn't.
They used standard ChatGPT.
They treated a general-purpose language model, literally a tool designed to sound human, as if it were a highly specialized, vetted legal search engine.
And the results were catastrophic. I mean, ChatGPT didn't just give them slightly bad advice. It fabricated 6 entirely fake judicial opinions out of thin air.
Completely hallucinated them.
Yeah, it made up plausible-sounding case names. It generated fake quotations from real judges who never actually said those words. And to make the illusion complete, it invented fake internal citations.
Right, those little strings of numbers and letters that tell a lawyer exactly which volume of a legal report or a case is printed in.
Exactly. And the AI formatted those fake citations flawlessly. Flawlessly. It mimicked the syntax and cadence of judicial writing perfectly. So when the opposing counsel and the judge tried to look up these cases to verify them, they obviously found absolutely nothing.
Nothing at all.
And Judge P. Kevin Castell of the Southern District of New York demanded the lawyers produce the actual text of the cases.
And this is the part that blows my mind. Instead of realizing their mistake, the lawyers went back to ChatGPT and asked it to provide the full text of the fake cases.
Unbelievable.
Which the AI happily generated, inventing pages and pages of completely fictional legal reasoning.
Just doubling down on the hallucination.
Yep. And when the truth finally came out, Judge Castell came down on them with a $5,000 joint and several sanctions under Rule 11.
We should probably clarify what that means technically, because it really sets the standard for everything that follows. Rule 11 is the federal rule that essentially says, by signing this document, I, the attorney, certify that to the best of my knowledge, formed after a reasonable inquiry, these legal contentions are warranted by existing law.
So it's a pledge.
It is. It is a fundamental pledge of honesty to the court. And joint and several means the court doesn't care how the lawyers divide the $5,000 fine between themselves. The court is holding all of them, collectively and individually, responsible for the full amount until it is paid.
But what I find really compelling about the Mata decision is how Judge Castell framed his ruling. Because he didn't ban the technology.
No, he didn't.
He didn't say, no one is allowed to use AI in my courtroom.
No, he established the precedent that, well, the tool is not the problem. His exact phrasing has become canonical in legal circles. He wrote, technological advances are commonplace, and there is nothing inherently improper about using a reliable artificial intelligence tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings.
The gatekeeping role. So the court is basically saying, we don't care if you use an abacus, a team of paralegals, a Google search, or a neural network to draft your brief.
Right, whatever works.
But you, the human lawyer, with a license to practice, are the ultimate gatekeeper. You are the firewall between the machine and the sanctity of the court record.
And it's a perfectly logical standard in theory. The problem, as the CLG newsletter documents extensively, is that the human firewall almost immediately started crumbling.
Really fast.
Yeah, just 7 months after the Mata case, we get a decision from the Second Circuit Court of Appeals in early 2024, Park v. Kim.
Right. An attorney named J.S. Lee cited a non-existent decision in a reply brief. And when challenged, she openly admitted she generated it using ChatGPT.
Yeah.
But it's the Second Circuit's response here that really highlights the visceral professional humiliation involved.
They didn't just issue a fine. They referred her to the court's grievance panel, noting she made absolutely no inquiry into the validity of her arguments, which is a direct violation of that core Rule 11 standard.
But the punishment was so specific. They ordered her to deliver a translated copy of this disciplinary decision directly to her own client. I mean, I want you, the listener, to really imagine the psychology of that moment. Imagine you're a client. You pay a lawyer thousands of dollars to represent you in federal court. Then your lawyer calls you into their office, sits you down, hands you a legally mandated translation of a court order, and has to explain, the federal court ordered me to tell you that I used a chatbot to make up fake laws, I didn't check my work, and I got caught.
The destruction of attorney-client trust is just absolute in that moment.
Completely.
You would think that level of professional humiliation would serve as a massive deterrent. But the dangerous misconception here is assuming this only happens to struggling solo practitioners or lawyers who just aren't technologically savvy.
Oh, absolutely. Which brings us to early 2025 and the case of Coles v. Ellison in Minnesota. This case is frankly mind-boggling because of who was involved.
It really is.
So the Minnesota Attorney General is defending the state's law against deepfakes. This is a law specifically designed to combat AI-generated misinformation.
Right.
And to support their case, they retain an expert witness, Professor Jeff Hancock. He is the director of the Stanford Social Media Lab. He is literally a world-renowned, credentialed expert on the dangers of AI and misinformation.
And the irony is almost painful here. Professor Hancock needs to draft his expert declaration for the court. So to help draft a document about the dangers of AI, he uses GPT-4o.
Wow.
And the AI hallucinates. It inserts two entirely non-existent academic articles into his sworn declaration, and it misattributes the authorship of a third real article.
And Judge Laura M. Provenzino ended up excluding his declaration entirely. Her framing of this is just brilliant. She pointed out that this credentialed expert on AI dangers had, quote, fallen victim to the siren call of relying too heavily on AI in a case that revolves around the dangers of AI, no less.
That phrase, the siren call, is vital to understanding the psychology of what is actually happening across the legal profession. I mean, why is AI so seductive? Why do brilliant people abandon their verification protocols?
Yeah.
Well, first, there is the crushing structural pressure of the legal industry. The billable hour model demands incredible efficiency. There are impossibly tight deadlines.
Always.
And when a piece of software promises to synthesize 10 hours of dense legal research into a clean summary in 10 seconds, well, the temptation to skip the tedious verification step is immense.
Okay, I have to jump in here.
Yeah.
Because I understand being tired or, overworked. But this feels a bit like using a shiny new GPS that confidently instructs you to drive directly into a lake and then standing on the roof of your sinking car blaming the satellite.
That's a great analogy.
Right. Like, how are highly educated experts, people who literally study AI misinformation for a living, failing to double-check their own work before submitting it to a federal court?
To understand that, you really have to understand the fundamental mechanics of what these large language models are actually doing versus what lawyers think they are doing.
Okay, break that down for me.
For decades, a lawyer's primary digital tool has been a legal search engine like Westlaw or LexisNexis. When you type a query into Westlaw, it uses Boolean logic to retrieve a document that physically exists on a server. It finds a real thing and displays it.
Right. It's basically a highly advanced filing cabinet.
Exactly. But a large language model is not a search engine. It is not retrieving a document. It is a prediction engine.
Ah, okay.
It generates text, word by word, token by token, based on statistical probability maps created from its training data. So it is essentially writing a story about a legal case that sounds mathematically plausible.
So it's guessing.
Very educated guessing. Because the training data includes millions of real legal briefs, the AI knows exactly how a legal citation should look. It knows the exact tone a judge uses. It doesn't hedge.
It sounds confident.
Extremely confident. It says, in the landmark decision of Smith v. Jones, and generates a perfectly formatted citation. And the output looks so incredibly correct, so familiar to a lawyer's eye, that it completely bypasses their critical thinking filters.
So if you are listening to this and you hire a lawyer tomorrow, you have to realize that the dynamic has fundamentally shifted. You are no longer just paying for their encyclopedic knowledge of the law. You are relying on their discipline to act as a human gatekeeper between a machine's very convincing hallucinations and your actual real-world legal reality.
And what the CLG newsletter source reveals next is that the crisis did not stop with the lawyers. The gatekeepers failed. And because the lawyers failed to catch the errors, the hallucinations breached the inner sanctum of the justice system itself.
Which means we must examine what happens when the judges, the ultimate arbiters of truth, start inviting this exact same technology into their own chambers. If the lawyers are struggling, the idea of a judge using these tools is terrifying.
It represents a massive paradigm shift. We move from lawyers getting caught and sanctioned to judges actively and openly using these probabilistic tools to interpret the law and decide cases.
The signature case for this, the one that really made the legal community's collective jaw drop, happened in the 11th Circuit Court of Appeals in 2024. Snell v. United Specialty Insurance Co.
Right.
Judge Kevin Newsom issued a concurrence where he enthusiastically detailed his own use of generative AI.
For context for the listeners, a concurrence is an opinion that agrees with the final decision of the court, but offers a different rationale or additional thoughts.
Right. So the court is debating a case about an Alabama insurance policy. And the entire multi-million-dollar case hinges on the ordinary meaning of a single word: landscaping. Does the policy cover this specific type of landscaping or not?
A classic contract dispute.
Exactly. And to figure this out, Judge Newsom decided to ask ChatGPT and Google Bard, which is now Gemini, to define the ordinary meaning of landscaping.
He essentially used the AI as a hyper-advanced probabilistic dictionary to determine the legal parameters of a binding contract.
And his candor in the opinion is astonishing. He openly wrote that he initially thought the idea of using AI for this was positively ludicrous, but after trying it, he declared himself a firm maybe, stating that it was an issue worth exploring.
The normalization process happening here is profound. A sitting federal appellate judge is publicly signaling to the entire legal community that consulting a probabilistic chatbot to define a key legal term is acceptable mainstream judicial behavior.
But hold on, I have to push back on the outrage here. Is a judge using ChatGPT to define landscaping really that different from a judge pulling a Merriam-Webster dictionary off the shelf?
That's a fair question.
Right. Judges look up definitions all the time. Why is opening a book perfectly fine, but asking an AI an existential threat to the legal system?
That is the exact defense many proponents of judicial AI use. But the difference is structural and profound. A dictionary is a static, vetted, historical record of language curated by human lexicographers.
Yep.
When a judge cites Merriam-Webster, any lawyer can open that same edition and verify the exact same definition. It is reproducible.
It's fixed.
Right. ChatGPT, however, is a dynamic generative model. It custom tailors an answer based on your specific prompt. If two different judges prompt the AI slightly differently, or even ask the exact same question on different days, they might get entirely different definitions, complete with different synthesized contexts.
Wow.
You are outsourcing the interpretation of language to an opaque algorithm whose primary goal is not accuracy, but plausible text generation.
And it wasn't just happening in the U.S. Our sources take us across the Atlantic to the U.K. In September 2023, Lord Justice Colin Burrs of the Court of Appeal of England and Wales is speaking to an audience at the Law Society. He casually mentions that he asked ChatGPT to summarize a complex area of law, and then he just put it in his judgment.
He famously called the tool jolly useful.
Jolly useful. and then he said this crucial line to me to head off the criticism. He said, I'm taking full personal responsibility for what I put in my judgment. I am not trying to give the responsibility to somebody else.
Which perfectly encapsulates the framework that many courts frantically tried to adopt to manage this. The newsletter points to Judge Scott U. Schlegel of the Louisiana Fifth Circuit Court of Appeal, who published a framework for judicial AI use in late 2025.
What was the framework?
He distilled it into a 2-line rule that chambers across the country started copying. The rule is, AI is a tool that belongs in the workflow, but not on the bench. We can use Gen AI, but we cannot outsource our judgment.
Okay, let's scrutinize that. In the workflow, but not on the bench.
Yeah.
I just don't see how that boundary exists.
It's very blurry.
All right, if a federal judge, like Judge Newsom, uses ChatGPT to define the word landscaping, and that AI-generated definition decides whether an insurance company takes out a massive claim, hasn't he already outsourced a piece of his judgment?
You are identifying the central contradiction of the judicial embrace of AI. The distinction between administrative workflow and core judicial judgment is largely an illusion when dealing with generative AI.
Why is it an illusion?
Think about the mechanics of summarization. If a judge uses a basic spell checker, that's workflow. It corrects a mechanical error.
Sure.
But if a judge uses a tool to summarize 100 pages of dense case law like Lord Justice Burrs did, the AI is making complex editorial decisions. The algorithm is deciding which facts are important and which facts are irrelevant. It is actively synthesizing legal philosophy. And selecting what matters is the very essence of judicial work.
So the AI is quietly shaping the narrative, filtering the facts, before the human judge even makes the final call.
Precisely. And when Lord Justice Burrs claims she takes full personal responsibility, it sounds noble, but it falls apart practically.
How so?
Well, if a judge relies on an AI to summarize cases because they literally do not have the time to read the primary sources themselves, how can they possibly take meaningful personal responsibility for the accuracy of that summary?
They can't.
No, they lack the independent capacity to verify the machine's output. They are trusting the AI's judgment and merely signing their name to it.
They are rubber stamping the hallucination engine. And that theoretical danger, the terrifying idea that judges might accidentally stamp a machine's hallucination into the permanent legal record, became a harsh reality.
Yeah.
Because in 2025, this stopped being a philosophical debate in legal journals. The arbiters of truth were caught out.
The theoretical risks materialized in the worst possible way. We transition from lawyers getting sanctioned and judges exploring the tools and concurrences to actual binding court orders being infected with fake law.
Let's look at the state courts first. June 2025, the case of Shahid v. Issam in the Georgia Court of Appeals. We have an attorney, Diana Lynch, who cites 2 fictitious cases in her filings at the trial court level.
Right.
But here's the horrifying part. The trial court didn't catch it. The opposing counsel didn't catch it. The trial judge actually adopted the fictitious cases in their official order.
The court's binding legal order rested entirely on authority that did not exist in this dimension.
The fake law successfully infected the system. And it only unraveled because the attorney, Lynch, appealed the case and got incredibly greedy.
What did she do?
She added 9 more fake cases to her appellate brief, bringing her total to 11 bogus citations out of 15.
Wow.
Yeah. The Georgia Court of Appeals finally caught the sheer volume of fake law, vacated the underlying trial court order, and hit her with the maximum frivolous motion penalty. But the structural damage was done. A trial court had codified a hallucination.
And you have to ask, how does that happen? Well, because the human gatekeeper model, Judge Castell's firewall, is incredibly porous.
Right.
Trial judges are overwhelmed. They manage massive dockets. They operate on an inherent assumption that officers of the court are telling the truth. If a citation is formatted correctly and the reasoning sounds mathematically plausible, a busy trial judge doesn't always have the resources to pull the physical reporter and verify its existence.
But surely that's just state trial courts, right? Surely the federal judiciary, the highest and most elite levels of the system, have better safeguards in place.
You would hope so. But the source material details an explosive revelation from October 2025 that shattered that assumption entirely.
Ugh, the October letters. In late 2025, the director of the Administrative Office of the U.S. Courts, Robert J. Conrad Jr., received 2 remarkable letters.
Very remarkable.
These letters were prompted by direct inquiries from Senate Judiciary Committee Chairman Charles E. Grassley, who was demanding transparency regarding AI in the federal courts. These letters forced 2 sitting U.S. district judges to publicly confess, on the record, that their own chambers had issued AI-tainted opinions.
Let's examine the first one. U.S. District Judge Henry T. Wingate in the Southern District of Mississippi.
Right. And just to be clear, we're not taking a stance on the politics of this case. We are just looking at the mechanics of the legal failure here.
Exactly.
Judge Wingate issued a temporary restraining order blocking a Mississippi state statute, specifically an anti-DEI statute.
Yeah.
Now, a temporary restraining order is a massive lever of judicial power. It immediately stops the government from enforcing a law.
It's a huge deal.
But the order Judge Wingate issued was a total mess. It referenced parties that were not even involved in the case, it misquoted the actual state law it was blocking, and it cited a completely non-existent legal decision.
And when forced by the Senate inquiry to explain how a federal judge signs a fabricated order of that magnitude, Judge Wingate's letter revealed the culprit. A law clerk in his chambers had used a generative AI tool called Perplexity.
Oh, wow.
The clerk used it to, quote, synthesize publicly available information on the docket.
And Judge Wingate called the signed order an early draft that had not gone through the standard review process and was mistakenly docketed. He said, this was a mistake.
And to fix it moving forward, he had to mandate that a second law clerk independently review everything, and he required physical printouts of all cited cases from Westlaw to be attached to final drafts.
The corrective measures are telling, but let's look at the second letter first before we analyze this systemic failure.
Yeah.
U.S. District Judge Julian Xavier Niels in the District of New Jersey. This was the CorMedix case, a federal securities class action. We are talking about massive financial stakes, corporate liability, the works. Judge Niels issues an opinion denying a motion to dismiss. And the published opinion is riddled with egregious errors.
Riddled with them.
It is fabricated quotations attributed to real cases. It completely mischaracterizes the outcomes of other major decisions. It even contained fake quotes attributed to CorMedix, the defendant company itself. The opinion was an absolute disaster and had to be officially withdrawn from the docket.
And the explanation provided by Judge Niels. A temporary assistant, specifically a law school intern working in the chambers, had used ChatGPT to perform legal research and draft portions of the decision, violating both the chamber's internal policy and their law school's policy.
Okay, I have to be honest here. Hearing these letters, it feels a bit like the classic "my dog ate my homework" excuse, but elevated to the federal bench.
It really does.
My intern used ChatGPT. My clerk used Perplexity. If a federal judge physically signs an order, effectively turning it into the binding law of the land, does it matter who or what drafted it? Shouldn't the judge be reading the actual cases they are citing to block state laws or decide multi-million-dollar class actions?
Your frustration highlights the exact systemic vulnerability this technology is exploiting. The entire U.S. judicial system at the federal level is fundamentally reliant on an apprenticeship model.
Right.
Federal judges have staggering dockets, hundreds of complex cases simultaneously. It is physically impossible for a single human being to read every single brief, verify every single citation, and draft every single opinion from scratch.
So they have to delegate.
Exactly. So they rely on elite law clerks, usually top graduates from Ivy League law schools and interns, to do the heavy lifting of research and initial drafting.
It's a chain of trust.
Yes. It's a highly calibrated chain of trust. The judge trusts the clerk to have meticulously read the primary sources. The clerk, historically, trusted the established, vetted databases like Westlaw. But now, that clerk or intern is quietly trusting ChatGPT or Perplexity to save time.
And when it fails?
When the AI hallucinates and the overworked clerk doesn't catch it, they pass the draft up to the judge. The judge, trusting their elite clerk, reviews the logic, assumes the citations are real, and signs it. AI didn't just break the digital research process, it broke the human chain of trust inside the judge's chambers.
And you have to wonder, if Senator Grassley hadn't forced this public transparency through the committee, would we even know about this? How many similar errors, maybe smaller ones that don't make headlines, are just sitting out there undetected in federal court orders right now?
That is the terrifying unknown that haunts the legal academy right now. The transparency pushed by the Senate Judiciary Committee is crucial, but it only touches the most blatant failures.
Which perfectly sets up the data, because it is really easy to hear these stories, Mata, Coles, the intern in New Jersey, and dismiss them as isolated anecdotes. You could just brush it off and say, well, that's just an incompetent intern, or that's just a lazy lawyer who didn't verify their work.
Right, blame the user.
Exactly. But the data provided in this CLG newsletter reveals that this is not an anecdote. It is a terrifying structural failure.
The empirical data here is what truly shifts this narrative from a series of embarrassing professional blunders to a full-blown crisis of confidence in the legal system's infrastructure.
Let's start with the tools themselves, because we aren't just talking about people foolishly using the free version of ChatGPT anymore. We're talking about premium, multi-million-dollar AI tools custom-built specifically for lawyers by the biggest, most trusted legal publishers on earth.
The heavy hitters.
Yep. The source cites a landmark 2025 study from the Stanford Reg Lab and of a Stanford Institute for Human-Centered AI titled AI on Trial. They rigorously tested the leading purpose-built AI legal research tools, and the numbers are jaw-dropping.
The Stanford researchers found that Lexis Plus AI has a hallucination rate of 17%.
And Westlaw AI-assisted research has a hallucination rate of 33%, 1 in 3.
Stated plainly by the researchers themselves, at the Westlaw rate, roughly 1 of every 3 answers in a legal research session contains a hallucinated or misgrounded element.
I am truly aghast at this. Let me try an analogy here. If I bought a calculator at the store and it gave me the wrong answer to basic addition 1 out of every 3 times I used it, I wouldn't keep using it for my workflow.
No, you wouldn't.
I'd throw it in the trash. How in the world are premium legal tools costing law firms absolute fortunes allowed to operate with a 33% failure rate?
Well, to understand that failure rate, we need to dive into the technical mechanics of how these specific tools are built. We have to differentiate between generic AI like standard ChatGPT and what Lexis and Westlaw are using, which is a technology called retrieval augmented generation, or RY.
Okay, let's break down AG. My understanding is that AGI is basically supposed to be the safety rails. It forces the AI to look at real documents before it speaks, like a student taking an open book test instead of guessing from memory. Is that close?
That is a very good analogy, but let's look at why the student still fails the test 33% of the time.
Right.
Generic AI just generates text based on its vast, unfiltered training data from the entire internet. It easily invents fake cases because it's just guessing plausible word combinations. ARGI is designed to fix this by grounding the AI.
Grounding it how?
With ARG, when a lawyer asks a legal question, the system first acts like a traditional search engine. It retrieves actual, verified, real cases from the massive Westlaw or Lexis databases. It grabs those real documents, puts them in a secure digital sandbox, and then instructs the AI language model. Only generate your answer using these specific, verified documents.
Cause the AI an actual legal reality.
In theory, yes. It significantly reduces the invention of completely fake, out-of-thin-air cases, like we saw in Mata. But here is the critical flaw that leads to that 33% hallucination rate. AI language models, at their core, do not possess legal reasoning.
They don't actually understand the law.
No, they only understand syntax, vocabulary, and semantic proximity, how close words are to each other in a mathematical vector space.
So they are reading the words, but they don't grasp the logic behind them.
Exactly. Let's say the RA system pulls case A and case B to answer a query. Case A established a broad legal rule. Case B is a newer case that specifically overruled case A on a very complex, narrow technicality.
Okay, so there's a conflict.
Right. A human lawyer reads both and understands the hierarchy and the conflict. The AI, however, reads both, sees they share similar vocabulary and semantic structure, and might confidently generate a beautifully written summary that improperly blends the two cases together. Or it might completely misunderstand how case B altered case A.
It creates a misgrounded element, as the Stanford study calls it. It's citing real cases, so the citations look perfect, but it is fundamentally lying about what those cases actually mean or how they interact with each other.
And for a practicing lawyer, a misgrounded interpretation of a real case is arguably more dangerous than a completely fake case.
Really?
Yes, because a fake case is easily spotted when you search for it. A subtly mischaracterized real case requires a lawyer to sit down, read the entire 40-page primary document, and realize the AI summary is logically flawed. It completely negates the efficiency of the tool promised.
And are the judges who are presiding over these cases aware of this 33% failure rate? Do they know the tools their clerks might be using are this flawed?
The data suggests a terrifying lack of awareness. The CLG newsletter highlights a March 2026 Northwestern Judicial Survey of federal judges. It found that 61.6% of responding federal judges have used at least one AI tool in their work.
Over 60%. That is the clear majority of the federal bench.
Yes. But here is the critical data point. 45.5% of those judges reported receiving absolutely zero AI training from their courts.
So you have a situation where the majority of federal judges are using tools that have up to a 33% hallucination rate, and nearly half of them haven't been given any formal training on how the technology works, its limitations, or how to spot misgrounded elements.
It's a massive blind spot.
That is a recipe for a systemic disaster. And we have the receipt for that disaster documented right here in the Charlatan Tracker.
Yes, Damien Charlatan's AI hallucination cases database. It serves as the public ledger of this escalating crisis.
The arc of this data is terrifying to watch. In May 2025, they had tracked 87 documented cases of AI hallucinations in courts. Just a few months later, by October 2025, it exploded to 486. By April 2026, it was 1,348 cases worldwide, with 915 in U.S. courts alone. And by May 2026, it hit approximately 1,455 cases.
And to put a fine point on the sheer density of this problem, Eugene Volokh, a prominent legal scholar writing for Reason, observed that on a single day, March 31st, 2026, there were 17 distinct U.S. court decisions referencing suspected AI hallucinations in court filings.
17 in one single day.
And as Volokh correctly notes, the true count is likely materially higher. Most state trial court opinions aren't even indexed in these major searchable databases. Furthermore, many hallucinations are simply never spotted by the opposing counsel, the clerks, or the judge. They just quietly become part of the legal record.
So if you, the listener, are involved in any kind of litigation right now, a contract dispute, an employment issue, a divorce, I want you to really absorb this reality. There is a very high statistical probability that the judge deciding your fate or the clerk drafting the opinion is using an AI tool.
Definitely.
There is a near 50% chance they were never formally trained on its risks. And there's a 1 in 3 chance that the premium tool they might be using is hallucinating its legal research. You are relying on a system that is fundamentally unstable.
It is a profound access to justice issue disguised as a technological upgrade,
which forces the system's hand. Because the numbers are so undeniable and the errors are so public, the courts have finally stopped issuing mere warnings.
And warnings weren't working.
No, they weren't. They've stopped just referring people to grievance panels. They're now bringing down the hammer. They're issuing devastating financial penalties and initiating absolute professional ruin. This brings us to the Q1 2026 sanctions wave and the immense cost of failure.
We are seeing the consequences transition from theoretical reprimands and embarrassment to catastrophic career-ending economic impact.
The macro number here sets the stage. In just the first quarter of 2026, U.S. courts imposed roughly $145,000 in AI hallucination sanctions.
And the bulk of that financial devastation came from one single landmark ruling in Oregon.
Let's talk about the Burgundy case, We have Stephen Burgundy, an attorney based in San Diego, and his local counsel in Portland, Tim Murphy. They are representing a client in the Valley View winery litigation. And across 3 different legal filings, they submitted an astounding 15 fabricated case citations and 8 completely false quotations.
It's a massive volume of fabricated material to inject into a single piece of litigation.
It is. But what makes this case a landmark in legal ethics isn't just the sheer volume of AI hallucinations, it's the aftermath. U.S. Magistrate Judge Mark D. Clark didn't just find them for being sloppy or trusting in AI, he heavily penalized them for the cover-up.
The cover-up.
Burgundy eventually realized the errors he had submitted, but instead of immediately falling on his sword, notifying the court and correcting the record, he tried to obfuscate and hide the mistake.
Which is a fatal error in the legal profession. The duty of candor to the tribunal is absolute. You can often survive an honest mistake if you own it immediately. You rarely survive the cover-up.
Judge Clark brought the hammer down with a $110,000 sanction. That included $15,500 in direct disciplinary penalties, plus over $80,000 in opposing attorney fees levied against Burgundy personally. And crucially, over $14,000 was levied against Murphy, the local counsel who didn't even draft the document but simply signed off on it so Burgundy could file in Oregon.
That is a critical warning for the legal profession across the country. Local counsel is entirely on the hook. You cannot just act as a mail drop, sign your name to an out-of-state lawyer's AI-generated brief, and claim ignorance of the contents.
Judge Clark's quote from the sanction order is absolutely brutal. He wrote, "Rather than a correction, Mr. Burgundy attempted a cover-up. He failed at both."
That line is going to be taught in law school ethics classes for the next century.
For sure. But even a 6-figure fine isn't the worst fate. The source details what happened in Nebraska to attorney Greg Lake.
This is where we see the ultimate professional consequence, the complete loss of the livelihood itself.
This goes back to the terrifying scenario we discussed at the very beginning of this deep dive. Greg Lake was arguing a divorce appeal in front of the Nebraska Supreme Court in February 2026. Out of the 63 case citations in his brief, 57 were defective in some way, and 20 were pure AI hallucinations cases that did not exist anywhere on Earth.
Just unbelievable.
And here is the nightmare scenario he is standing at the podium during oral arguments. He is looking up at the state's highest judges, and a Supreme Court justice looks down at him and confronts him about the fake cases live, in open court, on the record.
Try to imagine the sheer psychological terror of that moment. The highest court in your jurisdiction asking you to explain why your foundational precedent is entirely fictional.
And Lake's initial panic reaction was to deny it. He stood there at the podium and denied using AI. But eventually, the weight of the evidence and the pressure broke him. He submitted an affidavit formally admitting he used a generative AI tool to draft the brief without verifying the output, calling it a grave error of judgment.
And the outcome?
The Nebraska Supreme Court indefinitely suspended him from the practice of law. His legal career is essentially over.
It is an absolute tragedy for him personally, but it is the necessary immune response of a justice system desperately trying to purge a contagion. However, it's very easy for lawyers to look at Stephen Burgundy or Greg Lake and think, well, these are individual practitioners. They probably lack the resources of the mega firms. This is a small law firm problem.
Oh, but the source destroys that comforting narrative completely. And this brings us to perhaps the most shocking institutional moment in the entire briefing. We have to talk about Sullivan and Cromwell.
Sullivan and Cromwell is one of the most elite, prestigious, well-resourced law firms on the planet. They define what is known as big law. They have layers upon layers of brilliant associates and partners.
Right. They're representing clients in a massive Chapter 15 cross-border insolvency case. For context, Chapter 15 deals with international bankruptcies involving foreign companies with U.S. assets. We are talking about coordinating complex laws across oceans with literally billions of dollars at stake.
Highest of stakes.
Yeah. In April 2026, a partner at Sullivan & Cromwell, Andrew G. Dieterich, had to submit a formal, written apology directly to Chief Bankruptcy Judge Martin Glenn. Why? Because an emergency motion they filed contained roughly 28 erroneous AI citations.
28 errors in a single emergency motion from a top-tier global firm.
I just want to sit with the psychological horror of being that partner. You are at the absolute pinnacle of the legal profession, and you have to write on Sullivan and Cromwell's heavy, embossed letterhead to a federal judge, The inaccuracies and errors in the motion include artificial intelligence hallucinations. We deeply regret that this has occurred.
If we synthesize why this specific incident is the most important one highlighted in the entire newsletter, it is because it proves the risk is entirely structural. It is not an individual failing of tech-illiterate solo practitioners. The most elite law firm in the world, with essentially infinite resources, rigorous layers of human review, and access to the most expensive enterprise software, still fell victim to the AI hallucination trap.
So I have a massive question for you. If a solo practitioner in Nebraska gets suspended for 20 hallucinations, and a global mega firm submits 28 hallucinations, does this mean the traditional model of legal work is fundamentally broken? Is the traditional billable hour, where you pay a highly trained human to read primary cases and carefully write briefs, is it dead? Or is it just transforming into something else?
That is the pivotal question the entire system is struggling to answer. And the way they are adapting is by creating a deeply confusing, contradictory web of rules across different jurisdictions, while simultaneously spawning a billion-dollar cottage industry to fix the very problem that AI just created.
Let's look at the rules first, because it is a total mess for anyone trying to practice law right now. There is no unified national standard. It is a complete contradictory patchwork.
Exactly. On one end of the regulatory spectrum, you have Judge Brantley Starr in the Northern District of Texas. Back in May 2023, he instituted a mandatory certification rule. If you practice in his court, you must affirmatively sign a document certifying that you did not use generative AI to draft your filing, or if you did, that a human being checked every single word for accuracy. It's a high-friction barrier designed to force accountability.
But then you look at the Illinois Supreme Court. Their policy, which became effective in January 2025, is incredibly permissive. They literally published a policy saying the use of AI may be expected, should not be discouraged, and is authorized. They don't even require lawyers to disclose the use of AI in their pleadings.
And in the middle, you have appellate courts like the Fifth Circuit Court of Appeals, who proposed a circuit-wide rule regarding AI use, but then backed down, essentially arguing we already have Rule 11. If you lie to us or submit fake cases, whether it's caused by an AI hallucination or human incompetence, we will sanction you. We don't need a special separate AI rule.
It's absolute chaos for lawyers trying to practice across different state and federal jurisdictions. But what's truly fascinating to me is how the market is capitalizing on this chaos. Because the fear of these massive sanctions and the visceral fear of writing apology letters to federal judges has created a massive gold rush.
A compliance gold rush.
Let's look at the economics of Harvey AI as detailed in the source. Harvey is a legal AI platform built on top of OpenAI's models, but specifically tailored and secured for law firms. In March 2026, Harvey hit a staggering $11 billion post-money valuation. They are pulling in $190 million in annual recurring revenue.
And look at what it costs to access that technology. The industry-reported pricing, which the newsletter notes Harvey disputes certain aspects of, but serves as a solid industry, estimate places deployments at roughly $1,200 per lawyer per month, with a mandatory 20-seat minimum.
That's an annual floor of approximately $288,000 just to get Harvey through the door of your firm, over $250,000 minimum just to play the game.
But here is the catch. As we learned from the Stanford Reg Lab study on Westlaw and Lexis, even these elite, purpose-built tools hallucinate. RAG fails. So a law firm pays hundreds of thousands of dollars for the generative AI to write their briefs and synthesize their research at lightning speed, but they know they can't actually trust the output, so what do?
They have to verify it, which means the market has created an entirely new second tier of software products.
Exactly. Verification tools. Companies like VLEX offering Vincent AI, LawDroid's SiteCheck AI, or Lexis Brief Analysis. These tools are designed to do a rigorous 3-layer verification check on the first AI's output. They check for existence, does the case actually exist? They check for accuracy, does the case actually say what the AI claims it says? And they check for currency, is it still good law or has it been overturned by a higher court?
Wait, I really need to pause on the sheer absurdity of this economic loop. Law firms are paying hundreds of thousands of dollars for a generative AI tool that does the drafting work instantly but demonstrably lies up to 30% of the time. Then they have to turn around and pay humans at their massive big law hourly rates or buy more expensive software just to verify that the first expensive software didn't lie. Are we just creating a two-tiered justice system that only the mega-rich corporate clients can afford to navigate securely?
You have hit on the most profound societal inequality that this technological shift is creating. Sophisticated corporate clients, the ones hiring AmLaw 100 firms, understand the risks. They're demanding specific AI use clauses in their engagement letters. They demand audit rights to see how their data is used. They demand strict indemnity language, meaning if the law firm's AI hallucinates and loses the case, the law firm pays the damages, not the client.
The wealthy clients have the leverage to protect themselves from the technology.
Exactly. They get the immense speed and efficiency of AI, coupled with the safety of mandatory human verification and ironclad contractual protection. But everyday citizens do not have that kind of leverage or purchasing power. And the source highlights a specific, fascinating legal wrinkle that makes this inequality even worse for the average person: the Upsolve case.
This is a really important access to justice angle. Break down what happened with Upsolve. My understanding is they were trying to use a First Amendment argument to give free AI advice to people who couldn't afford lawyers, but they ran into a wall.
That's exactly right. Upsolve is a nonprofit organization that created a volunteer justice advocate program. They wanted to allow non-lawyers and eventually AI tools to give very narrow, specific legal advice on things like debt collection to low-income New Yorkers who simply couldn't afford real lawyers. In 2022, a federal district court ruled they could do this on First Amendment free speech grounds. That ruling essentially blocked the state's unauthorized practice of law, or UPL, statutes.
And UPL statutes are the state laws that say you can't practice law without a license, which are ostensibly there to protect consumers from scammers.
Right. And when that 2022 Upsolve ruling came down, many legal tech innovators looked at it and thought, this is the breakthrough. We can build AI chatbots to give free legal advice to the poor under the protection of the First Amendment. But the source details that in September 2025, the Second Circuit Court of Appeals vacated that 2022 decision. They ruled that UPL statutes are content-neutral regulations subject to what is known in constitutional law as intermediate scrutiny.
Let's define that for a second. Intermediate scrutiny means the government has to prove that the law furthers an important government interest, and does so by means that are substantially related to that interest. It gives the state a lot more power to enforce the law than strict scrutiny would.
Exactly. By applying intermediate scrutiny, the Second Circuit gave the state a much stronger hand to shut down these non-lawyer and AI access to justice tools to protect the licensed monopoly of the legal profession.
So to summarize this landscape, sophisticated corporate clients are utilizing $300,000 AI arrays, protected by complex verification software and indemnity contracts. Meanwhile, everyday citizens trying to use free public interest AI tools just to fight a debt collector just had their constitutional protections significantly weakened. The justice gap isn't closing with this technology, it is widening and becoming technologically entrenched.
The tools that could democratize the law are being heavily regulated, while the tools that accelerate elite legal practice, despite their massive hallucination rates, are becoming deeply embedded in the system.
Which brings us to the end of our deep dive today. This has been an incredibly heavy, complex, but utterly essential journey through the source material provided by the CLG newsletter. We have tracked an alarming, rapid evolution. We started with lawyers submitting fake cases out of sheer desperation or ignorance, like the infamous Mataviavianca case. We watched as the siren call of the technology seduced the bench itself, leading to federal judges accidentally docketing AI hallucinations because the traditional chain of trust with their clerks was fundamentally broken by the tools. And we've arrived at an $11 billion industry desperately attempting to verify and fix the chaos that it just unleashed on the legal system.
The structural integrity of legal precedent, the very foundation of how we determine what is true and lawful, is currently undergoing the greatest stress test in modern history.
So if there is one direct, actionable takeaway I want you, your listener, to carry forward from this deep dive, it is this. The next time you sign a business contract, enter a personal dispute, or hire counsel for any reason, you must be your own ultimate advocate. You cannot blindly trust the system's infrastructure anymore. Ask your lawyers directly about their AI protocols. Demand human verification in writing, because the courts are actively struggling to keep the gates closed, and you absolutely do not want your life, your business, or your freedom decided by a machine's hallucination.
I completely agree. And I would leave you to consider this final, chilling extrapolation of where all this empirical data points us. If lawyers are now routinely using AI to draft 100-page legal briefs, and judges, crushed by their massive dockets, are using AI to summarize those exact same briefs and draft their binding rulings, we are rapidly approaching a point of pure machine-to-machine litigation. The ultimate question you have to ask yourself is this: if a machine argues the law and a machine decides the law, at what exact moment in that process did a human being actually receive justice?
A terrifying question to end on. When we started this conversation, we talked about how we expect the law to be like structural bedrock, verifiable, and solid. But maybe we need a completely new expectation. Because right now, the bedrock is actively shifting and the architects of our justice system are relying on blueprints drawn by machines that dream. Thank you so much for joining us on this deep dive into the CLG newsletter. Stay curious, stay vigilant, and always, always check your citations.
Tune in next time on The Valley Current.